Hi, ladies and gentlemen. We are back with the SAP IP Business Talks. Today, we talk about design protection and the current developments, and especially how we can use design protection in a digitalized world. I had a LinkedIn post yesterday, and that was a lively discussion, which I pretty much enjoyed. And some of these questions I will ask my guest today, Kei Enomoto. And we are live on LinkedIn. The continuous visitors knows that, and that means you can write questions or comments in the chat for this event, and I will see that here in the studio, and when it fits anyhow, I will ask Kei these kind of questions. So, and now I'm happy that Kei is with us, and my first question, which I ask all of my guests, because my assumption is that a young girl don't wake up in the morning and says, I want to become an IP lawyer. So that's the rare case. So typically there is a certain process how that happens. And so we are in London today. I learned that. That's the reason why the weather is so beautiful. And here in Munich,
yes, of course.
it's unbelievable. Kai, how did you came into the field of, let's say, strange field of IP?
I was studying chemistry in France and then in the UK, and I went up to my PhD. I enjoyed it, but when I was coming out of my PhD, I kind of felt that maybe research is not my thing. And also, I was a catastrophe in the lab, and I thought for my safety and the safety of others, I'd better get out of the lab. And then just when I was looking at different careers, I wasn't aware about IP until I did my PhD, and I did it in collaboration with Syngenta. And there was an IP department, and I got a little bit familiar because I was helping out with translations. The big driver was my sister is a trademark attorney, and she just told me, well, how about patents? And so it all started. I started an IP firm. I started in an IP firm in Paris.
Okay. So it's a kind of family illness, right?
Illness might be the right word, actually. Yes.
Okay, great.
Not far off.
And so that explains why you speak with a French accent. And what brought you to London?
What brought me to London? Yes, studies, and I think so. Just by way of background, because some people always wonder, my parents are Japanese, but I was born and I grew up in France. And I now live in London with my German husband.
So it's very multicultural.
So geographically, London was good, but also having one of the reasons why I came to study in the UK was because there were those combined degrees where you could do chemistry and business, or very mixed subject matter to study, and that really attracted me. And beyond that, it's just I made the UK my home, and I've been now here for I'm not going to admit how many years.
No, it's not necessary. Don't count. No. Okay, wonderful. So you are here because we want to talk about design rights, and especially this huge challenge of our virtual reality, augmented reality, metaverse environment. So we have now digital experience environments. And yes. I learned from you that you will talk about that on the Euro Law Conference. That's why the banner is there. And that will be a bigger format, and you'll have a panel there with different experts. So that is obviously something very, very fascinating. Here we have these digital live format, and I want to talk with you about these issues. When when we have these digital environments and we have there created a design. So first of all, I would like to start really with the basics. So when is a design registerable, and what are the requirements when it is about a digital object, let's say an icon or any functional button or whatever? So can you explain us that?
Okay, I think that we need to go back a little bit more in terms of design protection. I don't know how familiar the audience is with design protection. I know that you have had some discussions about designs, probably in the past and also in the LinkedIn thread. I'm just wondering where would be the best place to start. Effectively, what we have is we have a very established IP right, which is designs, but we have a new technology or new developments in technology, which involves the digital animated designs and the virtual world. And as always, when we have such leap in the technological innovation, then the law has to follow and adjust to it. So in terms of the design, it is possible to register designs or to protect your designs in the virtual world in principle. Shall I just go straight into this subject?
Yes.
Yes.
I think that's absolutely fascinating.
Fine. So in terms of I can talk only about the UK and the EU from my perspective. In principle, yes, we can have design protected in the virtual world. And I'm saying that as opposed to, for example, in certain countries like Japan, you have the protection of your design in the UK and in Europe is not limited to the product or the article it's applied to. And what I mean by that is a little bit like those classifications of products. For example, I had a case where if you think about the Batmobile, the Batman car, the Batmobile, in Japan, you would have to register it under, say, toys, because someone could infringe a design in a toy, or in a vehicle, because someone could make it a life size and turn it into a vehicle. In the EU, you have to provide a Locarno class, but it's not limiting to that. The protection is not limited to that Locarno class, and it's broadly for search purposes. And in the UK, you can't even suggest a Locarno class. You just have a title that needs to be descriptive. In the UK legal text, so the RDA, the Registered Design Act, it says explicitly that the visual appearance of computer icons and screensaver graphics and the visual layout of software interfaces, that's GUIs, are registrable. So the appearance of any form of digital content can be accepted for registration. Mm-hmm. And in the EU, we have a similar wording and a similar scope. Now, where the law is changing and adapting to new tech is that we have a new EU design, a recast design directive in the EU, and an amended regulation as of this year. And they have changed the wording so that it is more adapted to now and to the digital world. And the definition of a design expressly includes the movement, transition, or any other sort of animation of the design features. And that's very helpful. I think that one of the worries that there was before, maybe in terms of enforcement, is that the definition of the design was around a product, So it wasn't very clear whether you needed to make something as a product that you can touch, right? And so that wouldn't be applicable to the virtual world. But now they have added to the definition, they're now specifying regardless of whether it is embodied in a physical object or materialized in a non-physical form.
Yeah, and I think, yeah, what you say with the transition and movement, I mean, that is really something which simply is not applicable typically to a physical object.
Exactly.
So a physical object typically in the real world don't morph from one to another. Maybe we have that, so a mimic like an umbrella, which you can open and close. But typically this is mechanically given how it works. And here when you say how you switch from one window to another, how a window is opened or closed, or how you communicate, so to speak, that that you can open something. So that kind of interactions are typically given by movements or transitions or changes. And that is something which is, I think, really a key difference, not just the static layout, but or the colors or something like that, but much more the way of interaction and what is communicated with that kind of interaction.
Absolutely. I mean, you're touching on something which is really interesting here, because you're talking about the movement and the interaction and so on. But of course, in terms of GUIs or icons and so on, you can have just the icon, say the Apple logo, and it's just there. It doesn't do anything. But you can also have animated design. So what we put in a big bag as animated design. And you could have an icon with an umbrella that opens and closes, or a plane which is taking off for a travel agency, or even just the buffer, the buffer circle. So these are all animated designs. And I think that where that becomes more relevant in terms of the law as well is how do you represent them at the patent office? As of today's date, basically you can't, the easiest would be if you could upload a video.
Yeah.
If you upload a video,
that would be the obvious way to do it.
That would be the obvious way. And I did mention that to a UK IPO hearing officer recently. And he said, nope, we can't do it at the moment. So maybe it's something that will come up with further development, but I think that it's more of, it's an IT platform, it's an online filing platform, so that might change, but that would be the obvious solution. But what is important here, I would say, in terms of the representation of an animated design, that can become something which is a little bit limiting when you're seeking protection. And you have to be very careful about how you show your design. And the reason for this is because the representations that you file to show your design is the same thing as the claims of a patent. It defines your scope of protection. And currently, the solution which is given to show, to illustrate your animated design is to have screenshot showing a sequence of images, right? So that at different moments in time, and so that there's a clear progression, which is very difficult because we don't know what happens between those images, number
Absolutely.
one. And also at the EU IPO, you can only file 7 images.
Oh.
So what happens if you have a longer, animated design? So
or a more complex,
absolutely,
a more complex behavior of the object.
Yes. So at the moment, this is how you represent your animated design at the EU IPO and at the UK IPO. And I think that the EU IPO has been very they have experience with GUIs and with animated designs, so they can take a step back from sometimes a very technical wording or literal wording of the regulation. So I had a case recently where something was different at the UK IPO. We are a few minutes into the discussion, and I'm already going to say the B word, Brexit, and I apologize for that. But obviously, now the UK IPO should be aligned with the EU IPO in terms of checking the representations, and I think that we got hooked on one technicality, which is all the views of an animated icon need to be visually related, and they must have features in common, and there must be a clear perception of movement and progression. And our UK examiner got stuck in that number of features in common because the image that we wanted to represent was an image appearing in scintillating images, in scintillating points. So all the points were not at the right place, and the image is appearing, so you don't have features in common. So we had to go up to a hearing where the hearing officer was able to take a step back and said, no, this is not what the regulation means. This is not what the text means. We can see that there is a progression. But obviously, all those discussions could be avoided if we could upload a video. I know I'm being a bit stubborn about this, but yeah.
Yeah, no, I got the point. This is exactly that kind of complexity. Let me say, for example, I imagine the Matrix, the video, so
yes,
the movie, and you have these letters and green and black. A black background, and then you see this curtain, and so this is dramatically characteristic. So everybody remembers that this is Matrix,
Yes.
But to describe that design really, and at the end, I mean, one thing is getting it registered. The next thing is getting it enforced. I mean, when you have gaps between, so time gaps between these different pictures, so then it is absolutely unclear what happens between them, and how can you then enforce it, because the infringer could always say, sorry, we don't do the same as it is registered here, because between these two pictures happens something what we don't know, and what we do has nothing to do with the registration.
Exactly. You could insert a subliminal image right in the middle, right? Absolutely. You're completely right. But then it means that effectively, if we take a strict application to enforce an animated design registration based on 7 snapshots, does that mean that it just suffices that you have those 7 images and then you are infringing? In the same way with a patent, if you have those features which are recited in the claim, regardless of what else is around it, you are infringing. So maybe that's the way it would be going for an infringement, enforcing that kind of registration with that kind of representation. There's also another, there's a complication as well, because if they think that the progression is not a progression, and maybe or it's often what you have when you have a lack of unity, all the representation must be directed to a single design. The UK IPO and the EU IPO are very reluctant to let you file amended drawings. And the only solution is to drop out, to delete that drawing from your application. And this is fine in some instances. In some instances, it means that you lose that sort of overall feel of the designs that you wanted to create, which would be a bit of a shame. But this is just a question out there. I just wonder about, the validity of the priority as well, because doesn't that mean that the scope of the representation is different if you are claiming priority?
Yeah, and I could imagine that let us assume it's the way how you open something. Okay,
Yes.
so at Apple, so I'm not using Apple, but I'm always fascinated when you have this bar at the this task bar, and then in an Apple, so you get these waterfall effect when something is opened or closed,
Yeah.
when an app gets open or closed. So, and let us assume because you want to have this look and feel, yeah, and you use now this effect to completely different objects, to a file, to when you download something, whatever, simply that you want that the users feel, let's say, at home because of these effect. And this effect is obviously because the objects are different, always a bit different. So it is the same effect, yeah, and it creates a certain look and feel. But you have more than 7 objects on which you apply to that,
That's right. Yeah.
which could mean that at the 8th object, which is a bit different to the others, simply because you have not the space, or it's a small object, whatever, you could not file that. And you have to 7 objects the registration, but not to the 8th one.
Well, you can file it. You just need to file 7 different design applications for each of the object, right? So, because if you have a progression in an image, then and every time it's just that you have that effect, but the object is different every time, then you can file one application for each object.
Yeah.
Obviously, if you want to apply it to anything and any image, that is just limit. There's no limit to how many you can file. It's a bit of a shame because, I mean, there are some processes to facilitate the filing of multiple designs, obviously. So you can file multiple design applications. And there are some tricks. For example, if I wanted to have this notepad, and you can also change your representation so that you have dotted lines to show different lengths and widths, for example. In Japan, they also have something which is quite interesting. They have something called related designs, where if you can have a starting color and a last color, and then effectively the way you file it, as I understand it, it protects all the colors in between. So, there are different possibilities in different countries, but everything relies on those drawings, those representations. And if I can add as well that there's another pitfall that we have to be a little bit careful when registering animated designs or icons or GUIs. There shouldn't be any user interaction. That's something that we've learned in another UK case last year. We had a medical device, like an imaging device, and you had a display, and the display is what we wanted to protect. And the display was figure 1, figure 2, up to figure 7, and it was different. But what the examiner realized, and what was later explained to us, was, yes, the user presses that button, and then you get the next image. And the fact that there is there. So it's not just like the buffer. It's not just like Matrix. You have to press something and then it goes to the next thing.
Yes.
And so, for example,
an interaction pattern.
In interaction, and in the examples that you just gave about appearing or disappearing image, you might need to click your mouse so that it happens and then stop it and something else. There would be a user interaction, and at that point, I think that the objection was, if there is a user interaction for the next image to appear, this would fall within the protection of a computer program. It's a computer-related invention, and therefore it's excluded from design registration.
Yeah, okay. Because we had yesterday, we had the discussion on the post, which was heavily discussed, by the way, and my announcement of our discussion today, and there was these a question from Maya Fenster, who said he thinks that design protection is too unflexible. And I asked him, "What do you mean with unflexible?" And then he said, "Naya, you have, yeah, you have also this technological layer. So it is most of the time when you design something, you want to not just visualize something, especially in graphical user interfaces. So you want also to have a certain functionality, and then we discussed that you need these layers of different IP, because one IP won't be able to protect your graphical user interface, obviously. So, and basically you could also use trademarks for it. So different aspects are then protected. But I think that is really something where a portfolio approach comes in. That once you have created something, then the discussion comes: how can we protect it anyhow? And is it would it make sense to integrate then IP experts in an early phase of the creation of this interface, let's say an app or whatever, that you create it in a way that it is as good as possible protectable? And because I could imagine that, that doesn't comes for free. So you have to make it that the registration is easy, that enforcement it can be done. Otherwise, you come up with something which is maybe even infringing third-party IP.
Absolutely. First of all, you answered that question exactly right. It's all about a question of layers, and it's all a question of IP rights being complementary to each other. You protect different things with different IP rights, okay? And design is very much focused on the appearance of your product or of your icon or GUI or interface or whatever. And the other thing that I also very much read and I appreciated in the thread, I had a look earlier today, is there were many comments from people who understood the relevance of design protection. I often feel that designs are underestimated and a bit overlooked, right?
Yeah.
When in fact it's such a useful addition to the IP arsenal. And this is exactly what you described. The IP arsenal is having a mixed IP portfolio wherever you can. It's really a belt and brace approach of protecting the inners of your product and the appearance of it, and then the branding of it. And a healthy portfolio has a good balance of all this.
Yeah, and I think just to jump in here, I think the design rights are, so when we look at, typically all of us sitting the whole day in front of screens.
Yeah.
Whichever screen, from your smartphone, from your iPad, at the television, at your computer. So being on screen, and the next round is we are in the metaverse. Well, I mean, we are right now in the metaverse. It is simply a very bad representation of the metaverse. And it's not that much meta, but we are used that we have a video conference, and hundreds of people can watch that.
Yes.
And in such experience environments, this look and feel, this feeling, creating a feeling of it. So, for example, feeling at home, or knowing that you are right now on a certain client or customer journey. So you are still with the product, you're still with an Apple product, and you see, or the German Bahn, the German railway system has an app, and you always know that you are on this app, and you see from the colors, from the design, you see that this is a representation of the Deutsche Bahn, and this is well done. I don't like the app, but it is well done that I know this is Deutsche Bahn. And insofar, I think these design rights are extremely important for this guidance of a customer. So functionality is quite often exchangeable, but your brand and making customers feeling at home with your brand, and this is a touch point, also an experience touch point for the brand. I think that is extremely important to understand why you don't want to be copied on that.
Exactly. I think so. I completely agree. And there is, of course, an obvious overlap with trademarks. Although with the trademark, what you're trying to achieve is to make sure that the user knows where the product comes from, or the originator, But for design protection, you can have different types of packaging, different kind of format or layout in the metaverse completely. And that's exactly right. And all this, I think that we had also in medical devices or in consumer products, the packaging, the design of the packaging, even the color patterns on a packaging can tell you where it comes from, and who is doing it. And and of course, there's a massive amount of infringement out there where they just copy the colors and then there's a different name on it, and that's where design infringement comes into place, because it might not be possible to prove that the alleged infringer was trying to say, well, this comes from this company, but design registration is, it is copied or it is not copied. It is the same or it is not the same, or similar, substantially similar. And what I like about design protection as well is that we talk about branding, but design can come from a product development perspective as a complementary protection to patents, but it can also come from a marketing and branding perspective as a complementary protection to trademarks. It sits right in the middle. And as I said, I felt that sometimes it's a little bit underestimated, but actually the number of design filings at the EU IPO and the UK IPO just speak for themselves. I think that quite regularly constantly in the past few years, there's been about 100,000 filings for EU designs. In the UK IPO, it went from 30,000 to 80,000 in about 3 years, but that is because of the UK leaving the EU. But the figures are good, and people are relying on designs. But sometimes people rely on designs only, or on patents only. And as you were saying, I think a mixed IP portfolio is probably the way to go. You were also mentioning earlier, sorry, you asked me and I blabbered on about something else. When it is good to talk with a patent attorney, just an IP advisor generally, and it has to follow. You need to have the right IP type at the right stage of product development. If you take the example of a mechanical device, like a medical device, one would normally start with patent protection when you're at the conceptual or the prototype stage, and then followed by probably designs once you have a good idea of what the device would look like. And if with that, maybe the device is used in combination with an app, or with a specific display, or a specific packaging, or just generally the shape of the device, then your design protection kicks in. And then when you commercialize it, then you can have your product name, etc., with your trademarks. And alongside that, your IP advisor will tell you where to keep it as a trade secret.
Yeah, to be honest, I have 2 points here.
Yeah.
The first point is, what exactly is an IP advisor? Yeah. So this is a huge issue out there, because yes, you have patent attorneys and you have design experts and you have copyright experts, and all of that fields are so terribly complex. So I'm always making fun about Udo Gennari. So Udo is a great guy, is an ambassador from the IP Business Academy, and the first time I met him was in a conference of the EPO in Ireland, and there was a little brochure. And every every participant or every speaker had a short CV and a claim. And he said, Udo says he works in for the Enterprise Europe network in Austria, and he had the claim, "I am expert for all questions about IP." And I said, Udo, I don't believe that. I don't believe that.
Well, if it is true,
This
well
is
done.
simply impossible. Yeah. And
Yeah.
that is such a huge challenge.
It
And
is huge.
I discuss that always with my students in IP management. So they are lawyers and attorneys and whatever. And I said, look, I don't talk with you about that you are a patent attorney. You are already a patent attorney. Now we talk about what could it mean IP management. And this is something completely different. So that's why I'm so focused on that. That's the one thing. So who to ask? Yeah. So who can really help with that kind of, and not, can you file me a patent because I have an invention? I mean, that is the easier part on that game. And the other thing is, I think these look and feel, this customer experience. And this is what I like so much from Steve Jobs when he said, no, don't start with technology and go the rest. Start with the user experience. And especially when we talk about software-based use cases or business models. So they really come from what should be the user experience. And this is exactly the time point when you should think about design rights. So what is the logic of the whole thing? What the user should do and how can we communicate that? And that comes to the point that designers typically have no clue about design rights. They simply do what they think is the best thing, and that at the end that cannot be protected is the worst case scenario, because then something is in the world and you can be copied as easy as it is digital.
Absolutely. I mean, to take your first point, who is an IP advisor? Anyone can call themselves an IP advisor. It doesn't give a measure of what, but I would say I would always go for someone that fits you and fits your needs, right? And fits your specific problem. My background is chemistry, as I mentioned earlier, but I'm actually working also heavily in mechanical inventions, and I also do designs. And by no means I am the best in each field. I will never proclaim that. And I also always say e-tech and software patenting is outside my scope of comfort, in terms of patenting or, some complex biotech inventions and so on. So it is finding the right advisor who knows and understands your tech. But it is also the right advisor with the experience in understanding what you need and at what stage.
Yeah, got you.
Right? There's no point in talking to you in legal jargon if you're a startup and you're just trying to figure your way out in the maze of intellectual property. Yeah. If I start talking to you about the directive, they could not care less. They just want to know, can I just produce this or am I going to get sued?
Okay, I have one. I mean, obviously, we have two pink elephants in the room. Yeah. So one you already mentioned, and this is the Brexit. And now I come up with the next one, maybe even bigger, and this is artificial intelligence. And because the Brexit just Europe and UK take care about more or less.
Yes.
But AI is a global phenomenon.
Yes.
And we have not that much time anymore. But I would like to ask you. So we have the copyright issue. So I think everybody knows, meanwhile, that there is an issue with copyrights when we talk about AI. And at least you typically have not the full copyrights when you generate something. It is not seen as something creative from a human. Then we have this discussion about patentability or ownership in who is the inventor when we talk about artificial intelligence supported invention processes. I'd be very careful. And then we have also, of course, the ability of IP to design something. I'm doing that every day when we create something. And the question is, what is with the registration requirements when you create a design by by AI?
The design registration is in terms of the formalities. Let's say at the UK IPO, you file your design, and you indicate the name of the IP owner. In terms of formalities, there will be no questioning about who the owner is. The ownership of the IP of the design rights of an AI generated design will not come into play until we have a litigation on this. And of course, this is a massive can of worms. You see it in copyrights. I mean, I've discussed AI generated designs with various organizations and with clients as well, because AI is everywhere. Everybody use AI tool because they're so good, but they're not perfect. They're still in training. But even if you just look at ownership, the owner can be the person who puts the information in, the programmer of the AI tool, the owner of the AI tool, and how about the people who inputted all those questions and previous designs? They trained the tool. They should be entitled potentially to some IP rights as well. So kind of worms there. We have to wait and see the developments, but they are, the common issues that that come out most frequently is the reliability of the tool, confidentiality, and one of the solutions is to use a closed system, ownership, the impact on the novelty and individual character of designs. If you have tools that can spit out thousands of designs in an hour, what would be the effect? And also the use of AI tools with IP professionals and patent offices.
Got you.
So I've gone very quickly through this because I'm quite conscious of time.
Yeah. Thank you very much. So let's talk a little bit about the Eurolaw conference. So you will have their panel, and what is what you want to discuss there? So let the people know what is the role then of design rights there.
Yes. So in the first week of June, we have that Eurolaw conference in Munich. And I will be expanding on this subject, but I will be there with two co-speakers, one from the US, Hailey Talbot from Seed IP, and the second from Japan, Miss Nikaido, who's a design attorney from Soei Patent Office. And I think that it will be very interesting to take that discussion on a global level. And this is only one of several presentations, and there will also be some discussions on the use of AI tools for patent professionals, patenting AI, SCP litigation, EPO decisions, and of course the UPC. And my apologies for the shameless plug-in here for the conference.
Oh, wonderful! The world of IP is so terribly intransparent, and also the events and what is presented there. And I think it is extremely important that we get more transparency, and that these initiatives which are done from law firms, from individuals, that they get a stage, and that people are informed what's going on, and everybody can decide then and make their own decisions on which events they want to go. But the information should be out there, and people should have an awareness.
Exactly. And as we were discussing earlier, the law changes with the tech out there, with the world around us. And therefore, for that law to change and to adjust, we need to discuss. And this is, I think, a really great opportunity to do so.
That's the one thing, and it is always good to meet people in person. And especially what I learned today about in the different jurisdictions, that we have different opportunities to file. That makes the things not less complex, it's more complex, and it's always good to have an expert on that. So, Kei, thank you very much.
Thank you.
The 45 minutes are over. It was very short about this fascinating topic. And to all of you out there, I wish you a great Tuesday evening. Bye-bye.
Thank you. Goodbye.